If you're separating and you're wondering how you sort out the arrangements for your children, then this vlog may be helpful for you. Hi, I'm Caitlin Jenkins, I'm the family law vlogger, and today's vlog is about the arrangements for children when people are divorcing or they're separating. Getting divorced or separating can obviously be a very difficult time for the adults, but also for their children. It can be a very unsettling time for children, and so being able to sort out the arrangements for where the children are going to live and how much time they're going to spend with each of their parents can be a very important first step, and something that it's very important the parents look at as soon as possible. Children may be unsure whether the separation is temporary or permanent, and depending on the ages of the children, sometimes they may also wonder whether the separation or the divorce is something to do with something that they have done as children. So it's very important at an early stage to think about what the arrangements of the children are going to be, and if possible and appropriate, to get some expert advice, perhaps from a counsellor or a therapist, about the best way for you to give some messaging to your children about what's actually happening, and also how you and the child's other parent are going to continue to try and communicate and co-parent, even if you're no longer living together. So how do you sort out the arrangements for where the children are going to live and what's going to happen to them? Well, in the vast majority of families, even when people are separating or divorcing, the couple manage to sort out the arrangements for the children themselves without too much help from other parties, whether that's counsellors, therapists, or indeed the court. There are court processes for sorting out the arrangements for children, but they should very much be a last resort rather than a first resort. And indeed, the courts will give parents a lot of encouragement to try and sort these things out for themselves, as it's the parents who know their children the very best. If parents can agree where their children are going to live and how much time they're going to spend with the other parent, then often there's no need for that to be recorded in a court order. Sometimes it's appropriate to do so, but actually that's the exception rather than the rule. Most of the time, parents agree the arrangements and just get on with it in practice. Sometimes they find it helpful to have a parenting plan, which you can find examples of on the internet, and they vary greatly in detail. So sometimes people have a very high-level parenting agreement or parenting plan, which just sets out where the child is going to live, how much time they're going to spend with each of the parents, and some basics about things like the children's birthdays or Mother's Days, Father's Days, holidays, those sorts of things. Sometimes parents find it useful to go through a much more detailed planning process and to have a more detailed parenting plan or parenting agreement, which covers all of the points that I've just mentioned, but also some more detailed points like approach to religious education or approach to the children's upbringing once they get to primary school or secondary school stage, and other major life decisions that the parents might want to agree up front as to how they're going to approach with their children. So if you can agree the arrangements for your children, it's up to you then to decide how you want to record it, whether you just trust each other to deal with it as you've agreed, or whether you want to have something written down in some form of parenting agreement. If you can't reach an agreement, then that's where other processes can often help. Mediation can be a really helpful process for helping parents work out what they want to do in terms of the arrangements for their children, and there's a separate vlog about the mediation process. There are also ways in which solicitors can sometimes help, so one or both of the parties could take independent advice from their solicitor as to the sort of normal approach that happens when people are separating and what might be the appropriate way forward in the circumstances that they find themselves in. And then, of course, there is also a court process for sorting out the arrangements for children if the parents can't reach agreement themselves. Before you can start a court process to sort out the arrangements for the children, you have to have attended either mediation or a mediation information and assessment meeting, which is called a MIAM. And the idea of that is that ideally, you having attended a MIAM and your partner having been invited to do so as well, you as parents would feel that you could enter into some form of mediation together to try and sort out the arrangements. But if you have attended a MIAM and either you don't feel that mediation is appropriate, or the mediator doesn't, or the other party won't attend mediation, then you can start a court process for sorting out the arrangements. Now, there's quite a lot of old terminology kicking around about the arrangements for children. People used to talk about custody, about access, about care and control, and even residence and contact orders these days are out of date. The applications that courts make are child arrangements orders, which are around where a child lives and how much time they spend with the other parent. So don't be too put off by the terminology. The last few years has been about simplifying that terminology. So we're talking about where children live, who they live with, and how much time they spend with the other parent. On what basis then would a court make a decision about what the arrangements for a child would be? Well, this is all about what's in the child's best interests, and the court's focus will be looking at what's in the child's best interests, not necessarily what's in the parent's best interests, or what that parent wants or what the other parent wants. So the focus is very much on what works for this child. The detail about how the arrangements for children tend to work and what happens in that process, including the involvement of CAFCASS officers and other potential experts to help the court come to a conclusion as to what's in the child's best interests, are the subject of other vlogs. But in overview, therefore, if you're divorcing or separating and you're wondering about what to do in terms of the arrangements for your children, the first thing to do is to try and agree those arrangements with your spouse or partner. And if you don't know how to go about that, or you don't know what those arrangements should be, then it is probably sensible to get some advice from a solicitor on that aspect. As always with the Family Law Vlog, if you want some specific advice about your circumstances and what you should be doing, then my details and those of the rest of the Mills & Reeve family team are at the end of this vlog.